guys, this is Leslie Sultan, estate planning attorney, and I'm just waiting for my guest to log in so we can begin. All right, welcome, Christina.
Hello, how are you?
Good, thanks. How are you?
Good.
Great. All right, so today we're going to be talking about Aretha Franklin. And if anybody hasn't seen there's a documentary on her. I think it's on Amazon Prime, but it's definitely a good documentary, although it doesn't talk about her estate plan. So we still need to talk about it today. So I'll just give a little bit of the history and then have Christina break it down a little bit in the legal terms. So as most people know, Aretha Franklin died without a will, which means that her estate has to pass through the laws of the state that she resided in, which in this case was Michigan. And but it turns out that they did discover wills after she passed away. However, the wills were not done properly and they were not taken into account. So let's talk about this a little bit, Christina, because I think this is a really important topic that we haven't talked about is why wouldn't a will count if you wrote a will? Like, can't you write a will on a napkin? So go ahead, Christina.
Yeah, so there's many different types of wills. There's something called a holographic will, is when you handwrite your wills. Most states, or a lot of states, do not allow that. A will has to be actually typed, either typewriter or now with computers typed and printed. And the reason they do that is because how do you know who really wrote the will? You know, trying to prove that somebody actually wrote it and those were their intentions is very difficult. Years ago, and during a lot of the, eras where there was wars, they allowed them because the soldiers would write things down very quickly and pack it on them so that their beloved ones back at home, their loved ones back at home, would know what their wishes are. So handwritten wills are really not the way to go. In addition to her wills being handwritten, she also did them, obviously she did them herself because she wrote them without the advice of any legal counsel. And so that was a big issue too, because one of her sons, I believe, had some mental illness and, really needed more planning than just writing, I leave everything to my children, or I leave specific things to specific children. So that's really, really why it's so important to have an attorney who not only prepares wills, but knows what to do in certain situations. When you have a loved one or a child that you want to leave something to that has special needs or has a mental illness or may one day have a mental illness or need governmental benefits or even getting into a car accident, becoming disabled, there's certain provisions in a will that must be there so that they don't lose their benefits.
Exactly, right. So we don't necessarily know what happened for her son, who I read was in a group home, but it's very possible that when he inherited that money, he lost some government benefits, which is, clearly not what Aretha Franklin would have intended for him. But what would somebody do if they had a child with special needs or a family member with special needs that they wanted to make sure to inherit without being penalized for the inheritance and losing government benefits?
There's different types of trust, one being a supplemental needs trust. And when you're funding it with an inheritance or somebody wants to gift you the money, it's called a third-party supplemental needs trust or SNT. And that's where you create the trust. It could be created as a sub-trust in your own trust, in the grantor's own trust. It could be a trust under somebody's will, or it could be what I consider a freestanding trust. So if my child had special needs and I wanted to open up a bank account and put $50,000 in it, I would create a freestanding supplemental needs trust for my child and put the money into that trust. That way, when time comes, if I'm no longer here, if anybody else, a grandparent, an aunt, an uncle wanted to add to it, they can name in their documents the supplemental needs trust as the beneficiary.
Great. And so we are in New York, and New York has very specific requirements for a will. I think it would be helpful for people to know what those requirements are in case they are planning to write one up themselves for some reason.
So in New New York, every will has to have two witnesses. Okay, there is special formalities that need to be done to make sure the testator had capacity. And if that will is ever contested or in question as to the validity, you go through what's called 1404 depositions. And one of the questions that gets asked almost always is, were certain questions asked during your will execution ceremony? New York law says you're supposed to have a will execution ceremony where the testator knows who they are, knows what property they have, and know what their will states, and make sure it's their intent to create that will and that they're not being unduly influenced or any duress going into it. So it's always important to have an attorney prepare your will because we know the right questions to ask. In addition to having the will, there's a second form called an attestation of witnesses that always needs to be attached to a will. And that's where the witness is signed in front of a notary saying that we witnessed the will, the testator wanted us to witness the will, and that they had capacity, that they knew what they were signing and they understand the English language and they can read, or if it's not English, it's in that language. So those are really, really important requirements for having a will. I also want to say when you have an attorney draft your will, we tell our clients, let your family members know where this important document is. For all estate planning documents, not just your will, but when we give you the package of your documents, we say, let your children know, let your spouse know, let your executor know where they are, and give them our contact information. Let them know that if God forbid anything ever happens to you, you call Leslie, you call Christina. In Aretha's case, she didn't do that because she hand wrote them. Nobody even knew she had them. It wasn't until 9 months later did they even find them. When we lose a loved one, we're not rummaging through paperwork and looking in shoe boxes in the back of the closet trying to find things. So having an attorney, we advise our clients, if you're naming John Smith as your executor, tell him, you're my executor. If something happens to me, call Leslie Sultan, call Christina Sammartino. That way they come to us and we have on record, we keep copies, we could say yes, and help from there.
Yeah, I think that's a good point. Yeah, so Aretha's, they found 2 or 3 of her old wills in a locked cabinet, right? So nobody had the keys, so it took them a while. And then they found one under a couch mattress. And I get this a lot with clients when we're preparing their estate planning documents. I ask them, do you have a safe deposit box? And they say, oh, yeah, we keep all of our documents there. We'll put the will there. And I say, no. Safe deposits are really the worst because nobody, unless they're a co-owner on that safe deposit box, can have access to that safe deposit box. They literally have to go through the full court process and get appointed in order to get access to that safe deposit box. So that's the worst place to put it. I mean, we've had stories of people putting it in a locked safe and nobody has the combination. So if you're going to...
Sorry, I say that all the time.
Yeah.
If you're going to put it in a safe in your home or a lockbox, that's great. But are your children or whoever you're designated, are they going to know how to get into that? That, or do they know it exists? Or again, is it in the back of your closet or stored away somewhere where, they're going to have to go searching, deep into it? Nobody's mindset is, oh, let's look in the back of, Great Grams's closet to find where she kept her important papers.
Right.
So that's why, attorneys can say, yes, she took the original, she has the original, it's there,
Yeah. And if it's not private, doesn't have, account numbers, and you just want to protect it from a fire, which is one of the big things, I recommend a fireproof bag, right? It doesn't get locked, and it will protect in case of a fire, which is the biggest harm we want to avoid.
Right. And really, to avoid all of Aretha's problems, she just should have had a trust created. A trust really would have resolved going through probate, going through this process. And she had a lot of assets. There was also the big issue with her IRS debt. She had significant IRS debt. Also going to an estate planning attorney, she should have divulged that information. When you have your initial consultation, we get a lot of information, and I know for me, sometimes clients are a little worried to share that information, but without having it all, we can't properly advise. And if, good estate planning attorney would have known that she had that large debt, they also would have been able to inform the executor or the trustee that this is what's coming along. Let's get 10 steps ahead of it. Let's resolve this right away instead of waiting so long. Her sons, her family, they couldn't reap the benefits of her royalties and, you know, her assets and in her estate, the licensing and the music from everything, until that IRS lien was resolved, which was only resolved, I think they said like last year.
Yeah, took years. Right. And then also the attorney could have advised her on how to negotiate the debt and pay it while she was alive, or come up with a payment plan that the family could have paid off. So yeah, because she had a cancer diagnosis, so they possibly knew that she was passing, you know, that her death was imminent, and definitely could have planned better. So it's a very unfortunate situation, and we talk about, you know, generational wealth and helping to build that wealth for generations. And it seems like Aretha wanted to do that. She just either, you know, didn't trust attorneys, or didn't know one that she trusted, or wasn't willing to go that route. So it was an unfortunate loss for her family that hopefully all of our viewers today, that all of you can avoid. If there's any questions, please submit them. Otherwise, any last comments, Christina?
No, just make sure you have all your estate planning and documents. Everybody I run into, they're probably sick of me saying it, but having a power of attorney, healthcare proxy, living will, and a will and/or a trust is really, really important. Everybody needs to have them. You know, Aretha Franklin was worth millions of dollars, and it still took all this time, a lot of legal fees to resolve her estate. With a good estate planning attorney as ourselves, you would avoid all of those fees. You know, there's no court intervention with a trust. If things are done properly and your goals are met, you know, things run very, very smoothly, so your loved ones don't have to worry about it or have, you know, the estate caught up in the courts for years and years and years.
Yeah. And the irony is, if she didn't trust attorneys or something, if that was the reason, attorneys got paid a lot of money to deal with that court probate. So yeah. Definitely better to find someone you trust while you're alive than have your family pay someone to deal with it later. Well, thank you guys for joining us. We're available for questions if you want to DM us later. And thanks for joining. Thanks, Christina. And we hope this was valuable for you.
Thank you for having me as always. Enjoy your night.
Thanks.